Welcome to episode 96 and the law report. In today's episode, I'm going to discuss the right of an accused person to confront his accuser. But before I do, my usual disclaimer, this is not legal advice, should not be considered as such. For legal advice, please contact an attorney of your choice. Welcome back. An important aspect of the right to a fair trial, which is well established at common law, is that a defendant is entitled to confront and cross-examine their accuser in court. It is also a well-established principle of open justice. However, some legal scholars believe that principles such as the right to confront your accuser and open justice can on occasions act as a barrier to justice. This can include where potential witnesses may fear that if their identities are revealed to the defendant or the associates or to the wider public, then they or their families or friends will be at risk of serious harm. Therefore, in recent years, the concept of special measures and special measures directions has become ingrained in our legal fabric throughout the English legal system and Commonwealth jurisdiction. Special measures legislation or witness anonymity legislation was introduced in countries such as the Cayman Islands, the Turks and Caicos Islands, in some form in Jamaica, in the United Kingdom, England and Wales, in some European countries such as Denmark, Finland, and Norway. And it is often argued that there are robust procedural safeguards in place to prevent any miscarriage of justice. And several other jurisdictions are having debates about implementing similar legislation. A few years ago, and I believe right up to last year, the BVI, the British Virgin Islands, were having such a debate. It is not clear if any legislation to this effect has yet been passed. The court usually gave effect to such legislation by issuing what is called witness anonymity orders if certain conditions prescribed by the legislative provisions are met. If such an order is granted, the identity of one or more witnesses may be withheld not only from the accused person, but from his attorney. In most instances, the witness only has to assert an element of fear which is perceived as real for such an order to be granted. The genesis, in my view, of special measures came out of the House of Lords decision in the case of R. and Davis of 2008, where a defendant in one case was charged with 2 counts of murder, and defendants in a second case with 2 counts of murder and 3 counts of attempted murder. At each trial, the judge ruled that the witnesses had a genuine fear if they gave evidence, and that their lives, that of their families and friends, would be endangered. Accordingly, they were allowed to give evidence anonymously. The testimony of those witnesses were decisive, or they were the sole evidence against the defendants. The defendants in both cases were convicted. The appeal to the Court of Appeal in England and Wales on several grounds. Surprisingly, the Court of Appeal dismissed the appeals and held inter alia that there was a clear jurisdiction at common law to admit incriminated evidence against a defendant by anonymous witness. Davis then appealed to the House of Lords. The House of Lords, in this case, disagreed with the Court of Appeal and allowed the appeals on behalf of the defendants. It held, 1, that it was a long established common law principle that, subject to recognized exceptions and statutory qualifications, a defendant in a criminal trial should be able to confront his or her accusers so that he or she might cross-examine them and challenge the evidence. 2, although witness intimidation has long been a serious threat to the administration of justice, there has been no departure from the rule until the court's recent authorization of witness anonymity that such a practice was irreconcilable with the common law, and that any departure from it was for Parliament to consider, not for the courts to create. 3, in allowing the appeal, the court held that the effect of the protective measures imposed by the judge prevented the defense counsel from investigating the witness or the witnesses or pursuing cross-examination, which would effectively have challenged the evidence given by the witnesses. The court held that the defense was hampered in conduct of its case, and as a result, the trial was unfair. The case was then remitted back to the Court of Appeal to determine whether or not there should be a retrial. Subsequent to this case, the law in England and Wales was passed, which gave judges the powers to allow witnesses to give evidence without their identity being disclosed. So, what is the position in the United States of America? And in this review, I lifted liberally and loosely from Cornell Law School website. And the Confrontation Clause is found in the 6th Amendment to the United States Constitution. The right to confront a witness is one of the fundamental constitutional rights that protects the citizens of the United States. The Sixth Amendment of the United States Constitution states that any criminal defendant suspected of committing a crime has the right to confront the witness in a criminal action. The right to confront a witness entails the right to be present at the trial and the right to cross-examine the witnesses presented by the prosecutor. Rule 43 of the Federal Rules of Criminal Procedure deal with the right to be present at trial. Specifically, the Confrontation Clause protects a criminal defendant against a conviction without an opportunity for the defendant to test the veracity of the testimony of the witnesses against them in front of the jury. The Confrontation Clause therefore safeguards the criminal defendant from a conviction solely based on written evidence, such as an ex parte affidavit. Further, the Supreme Court of the United States delineated the three essential purposes of the Confrontation Clause in the case of Mattox and the United States. One, the court held that it was to allow a criminal defendant to cross-examine any witness that testified against. Two, to make sure that the witnesses testify under oath and provide a reasonable understanding of the seriousness of their testimony within the trial. And three, to provide an opportunity for jurors to evaluate the credibility of the witnesses by presenting the witnesses in cross-examination to gauge the personality of the witnesses. The Supreme Court further established the Confrontation Clause role as preserving fairness in the criminal justice system in the case of Lee and Illinois, and upholding constitutional rights. However, the Supreme Court also stated there is an overwhelming government interest in protecting law enforcement effectiveness. If the government interest in effective law enforcement outweighs the benefit of confronting witnesses for the defendant, then the right to the government interest may supersede the right to confront opposing witnesses. In some rare circumstances, the court may then deprive the defendant of the right to confront witnesses in cases of the admission of hearsay evidence. And you could look up the case of Delaney versus the United States. In the case of Barber and Page, the Supreme Court indicate that there is a common law exception to the right to confront a witness when, one, the witness is currently unavailable, two, the witness testify against that same defendant, and three, the witness was cross-examined by the same defendant's party. Further, under the 14th Amendment, the right to confrontation applies not only to federal government, but also to the states. It is designed to prevent the defendant from being convicted and written evidence without the opportunity to face the accuser and test their honesty and truthfulness before a jury. So what is the position in the Turks and Caicos Islands? Well, let's look at Section 6.2e of the Turks and Caicos Islands Constitution. It states that every person who is charged with a criminal offense shall be afforded facilities to examine in person or by his or her legal representative, the witnesses called by the prosecution before the court, and to obtain the attendance and carry out the examination of witnesses who testify on his or her behalf before the court on the same conditions as those applying to witnesses called by the prosecution. You may therefore agree with me that this is not as decisive and potent as the Sixth Amendment Clause. So let's see how the English courts view the Sixth Amendment to the United States Constitution. In the case of Davis, 2008, at paragraph 68 to 71, Lord Mans review the Confrontation Clause of the United States. And he made the following observations. My noble and learned friend Lord Rogers said of the right of confrontation enshrined in the Constitution of the United States by the Sixth Amendment, that it is for the people of the United States, not for your lordships, to debate the virtues of the Sixth Amendment in today's world. It overlaps to some extent with Article 6.3d of the Convention as interpreted by the European Court, but as interpreted by the Supreme Court, the Sixth Amendment appears to go much further towards requiring as a check on accuracy that a witness must give his evidence under the very gaze of the accused. For my part, I would certainly not disparage the thinking behind that requirement. This line of thought never gave rise to a correspondent requirement in English law. This is amply demonstrated by the very brevity of the decision of the Court of Appeal in the case of R. and Smiley of 1919, where the court held that a judge could remove the accused from the sight of a witness whom his presence might intimidate. So in essence, the court is saying that in the English legal system, that the right to confront a witness does not go as far as it does in the Sixth Amendment to the United States Constitution. And while the Sixth Amendment appears to say that the witness must give evidence in the presence and under the gaze of the accused person, there is no such requirement under the English legal system. And that is why the court has held that a witness giving evidence without their identity being known is permissible once the defense or the defendant is afforded the opportunity to cross-examine. So to repeat, what I glean is that the English courts believe that the right of an accused person to confront their accuser does not mean that the accuser has to be known to the accused person, or that the accuser has to be present in the same room with the accused person during the proceedings, or once the accused or his legal representative is given an opportunity to cross-examine the accuser, then it does not infringe on the accused's right to a fair trial. You may agree or disagree, but there's also a fourth important point, and that is, once the accuser is not the sole and decisive witness, or his or her evidence is not the sole evidence determining the guilt of the accused person, then the trial is deemed to be fair. Here is where I'm going to leave this episode for today. I thank you for watching. Hope you have learned something. If you did, please like, please share, and please give it a thumbs up. And if you do not like anything that I say in this article, give it a thumbs down. But I will see you very shortly in my next episode. Cheers.